Works in Manatee County, but I've been an attorney for about 25 years, most recently with the city of Sarasota. So I've done a lot of local government law and mostly focusing the last, say, 10 years or so on labor and employment law. So I'm thrilled to get to talk to you about employment law. We're going to talk today just about discrimination law. There's a lot to tell you about that. We're going to start out talking about Title VII of the Civil Rights Act of 1964. We're going to move from that to section on the ADA, the Pregnancy Discrimination Act, retaliation, and a little bit about LGBT law, which is evolving. So I've got a couple little videos I'm going to show you through the way, but I'll try to keep the pace pretty fast so we can get through it. And then at the end of each section, I'll give you a chance to ask questions. Uh-oh, not moving. Let's see. There we go. Okay. So the Civil Rights Act of 1964 is a landmark piece of legislation that outlawed discrimination based on race, color, religion, sex, and national origin. We're going to focus on the Civil Rights Act of 1964, as I said, and it actually has 11 titles, including voting rights, public accommodations, desegregation of public facilities, desegregation of public schools, and then Title VII, which is what we're going to talk about, which bans discrimination in the workplace and creates the EEOC. This picture is pretty interesting. It's President Lyndon B. Johnson signing the Civil Rights Act in 1964. He had a whole lot of pens. He was sort of handing them out as souvenirs after he signed a little piece of the act. And interestingly, all guys back here, there really were very few women or people of color in Congress in the 60s. You can see Martin Luther King is standing behind President Johnson. So Congress has the power to regulate interstate commerce under Article I. And they also have the duty to guarantee all citizens equal protection under the law, which is the 14th Amendment. And they have a duty to protect voting rights under the 15th Amendment. So I'm going to try to start this little video for you, which talks about kind of a little bit of the background on how this law was passed. It's really short, but I think you'll enjoy it. It's got a lot of really cool black and white photos in it.
Congress passes the most sweeping civil rights bill ever to be written into the law, and thus reaffirms the conception of equality for all men that began with Lincoln and the Civil War 100.
Sorry about that. Here we go again.
Congress passes the most sweeping civil rights bill ever to be written into the law, and thus reaffirms the conception of equality for all men that began with Lincoln and the Civil War 100 years ago. The Negro won his freedom then, he wins his dignity now. 5 hours after the House passes the measure, the Civil Rights Act of 1964 is signed at the White House by President Johnson. Before an audience of legislators and civil rights leaders who had labored long and hard for passage of the bill, President Johnson calls for all Americans to back what he calls a turning point in history.
We must not approach the observance and enforcement of this law in a vengeful spirit. Its purpose is not to punish. Its purpose is not to divide, but to end divisions, divisions which have lasted all too long. Its purpose is national, not regional. This Civil Rights Act is a challenge to all of us to go to work in our communities and our states, in our homes and in our hearts, to eliminate the last vestiges of injustice in our beloved country. So tonight I urge every public official, every religious leader, every business and professional man, every working man, every housewife, I urge every American to join in this effort to bring justice and hope to all our people and to bring peace to our land.
There's warm applause from members of both parties as the president sets to work. It is work. He uses nearly 100 pens to affix his signature and date. Souvenirs go to Republican leader Everett Dirksen and Democratic whip Hubert Humphrey. The president seems to have mastered the art of just touching each pen to the paper. Integration leader Martin Luther King receives his pen, a gift he said he would cherish. The Department of Justice will enforce the law if necessary, and G-Man Chief J. Edgar Hoover is present. Another group of pens is reserved for the Kennedys, and the Attorney General is entrusted with a half dozen. Now, in this summer of 1964, the Civil Rights Bill is the law of the land. In the words of the President, it restricts no one's freedom so long as he respects the rights of others.
Let me see if I can get rid of this. Let's see.
Down at the bottom left, there's an arrow to go to the next slide.
There we go. Thank you. Okay, so this law was passed in 1964. It had originally been proposed by JFK, and of course, after he was assassinated, Lyndon Johnson became president. And he was able to get this through a Congress that really was not inclined toward this, in particular the southern states. The southern states, which were all Democrats at that time, so it was a kind of reversal of our red state, blue state situation that we have now. But he was able to convince the southern senators to go and representatives to go along with this. And this was against this backdrop of protests against racial inequality, including the Birmingham campaign. And the Birmingham campaign was essentially a part of the civil rights movement. Birmingham, Alabama was sort of seen at that time as one of the most segregated cities in America, one of the places where there was the most racial unrest. And Martin Luther King had gone there to help in the movement. And there, most of the, if you see anything on television that shows like protests from the 60s, where there's a lot of violence going on by the police, it was usually at Birmingham. They had fire hoses and dogs, police dogs that were attacking people. It was a very bad situation there. So the person I think that is with Martin Luther King here is, I think that's Malcolm X. So here's Martin Luther King on the Mall in Washington, D.C. There are like 250,000 people that attend this protest march. And this is where he makes his famous I Have a Dream speech. And I'm going to show that to you, a little video on that as well, because it really sets the context for this law's passage and shows you how instrumental Martin Luther King was in getting this law passed.
On a hot day in August 1963, Dr. Martin Luther King Jr. delivered a speech that would define the civil rights movement and his legacy. This, of course, was his I Have a Dream speech, delivered on the steps of the Lincoln Memorial during the March on Washington for Jobs and Freedom.
I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I have a dream today.
The March on Washington served as a massive push for economic and political justice for African Americans. Held during the year celebrating the 100th anniversary of the Emancipation Proclamation, crowds marched on the National Mall to watch a variety of musical performances and speeches. Dr. King, a Baptist preacher and prominent civil rights leader, was scheduled to speak towards the end of the day, his debut on the national stage. Up until that point, King mostly addressed small crowds at black churches, rallies, or fundraisers. This time, he would be seen by nearly 250,000 people on the ground, as well as millions at home watching on television. This was an opportunity to reach a wide audience and persuade the public and the government to take action against racial injustice. The night before, King worked with a close group of advisors to get the speech just right. They worked through the night, settling on a final draft in the pre-dawn hours of August 28. Interestingly, the phrase, "I have a dream," a phrase he used in earlier speeches, was nowhere to be found in this copy. The words wouldn't manifest until almost halfway into Dr. King's speech, when gospel singer Mahalia Jackson, who had performed earlier in the day, called out to him from the sidelines to tell them about the dream. King set his prepared remarks aside and improvised the rest, crafting a soaring speech that would sear into the minds of millions of Americans.
No, we are not satisfied, and we will not be satisfied until justice rolls down like waters and righteousness like a mighty stream.
The speech was divided into two parts. The first listed the injustices that African Americans faced: segregation, police brutality, disenfranchisement, and discrimination, and urged a call to nonviolent action. The second launched into King's dream of peace and racial harmony, a vision of a future in which people will not be judged by the color of their skin, but by the content of their character.
I have a dream.
Highlighting King's skills as a preacher, I Have a Dream was part sermon and part poetry, using rhetorical devices like repetition, rhyme, and vivid metaphor to drive his points home. It was peppered with historic, biblical, and literary references that moved the crowd. This message of struggle and hope became the defining moment not only of King's career, but also the civil rights movement. Both the speech and the March on Washington were credited with helping secure the passage of the Civil Rights Act of 1964, a landmark piece of legislation that ended segregation and banned discrimination on the basis of race or sex in the workplace.
Free at last! Free at last! Thank God Almighty! We are free at last!
The speech also resonated with activists around the globe. I have a dream. The phrase that wasn't even meant to be in his final draft appeared in political actions all around the world. It's considered one of the world's most transformative and influential speeches, alongside others like Abraham Lincoln's Gettysburg Address and Winston Churchill's Blood, Toil, Tears, and Sweat. I Have a Dream is only one of Dr. Martin Luther King Jr.'s many achievements, but it's nonetheless one of the most pivotal.
I am happy to join with you today in what will go down in history as the greatest demonstration for freedom in the history of our nation.
Okay. I want to talk to you just a little bit about the women's rights movement too. Basically what happened, I think, is the civil rights movement really galvanized women who had been experiencing a great deal of discrimination, especially in the workplace. Just sort of the evolution of this is that women had gone to work in the 40s when men went off to war, and then when the men came back, the women mostly lost their jobs. And so trying to get back into the workplace then in the 50s and 60s proved to be really difficult. Even women that had high qualifications, like Sandra Day O'Connor, who was a Supreme Court Justice, and Ruth Bader Ginsburg, both had trouble finding jobs as lawyers, even though they were like at the top of their class. And so women were not paid as well, obviously. And so they began to protest, and of course they were included in Title VII, but I wanted to show you just a little bit of a timeline of some kind of important moments in women's rights, in the women's rights movement. it'll be really quick. This is just a few items. The pill is approved in 1960, which makes a tremendous difference for women because they can, for the first time, potentially control reproduction. 1963, you have Betty Friedan writing The Feminine Mystique, which becomes kind of the manifesto for the women's liberation movement. And then you see that the Equal Pay Act is signed by President Kennedy. And the Soviets send the first woman into space. So by 1964, we have the Civil Rights Act, and that begins to change things, but it happens rather slowly. And you can still see that there are a lot of other issues that have to be taken care of after that. You have the case Griswold versus Connecticut, which is a US Supreme Court case in which the court said states could not ban contraceptives for married couples. Then you have that year that the EEOC is established. In 1967, the Equal Rights Amendment's proposed. And this is a pretty simple amendment that would just provide equal rights for women. And it's because it's a proposed constitutional amendment, it has to be approved by 3/4 of the states, 38 states. And they are at the end of the day, they're 3 states shy, so that doesn't pass. There is some effort to try to get that going again. There's 3 states in the last few years who have agreed to it, but then there's 5 states that want to not be a part of it. So I don't know that that's going anywhere now. But in 1973, you see the Roe v. Wade case, which does legalize first trimester abortions. And it's not till 1975 that women can serve on juries, which is kind of amazing. And then I just wanted to tell you this story too about how sex got added to Title VII. So it was originally just going to be race, color, and national origin. Religion didn't come in until like 1971, but sex wasn't even in there. And this Congressman, Howard Smith out of Virginia, at the last minute introduces a bill that would add sex to the list. And he had been opposed to the bill, so people didn't know if he was just trying to defeat the bill or if he really was trying to make sure that women had some protection. But in any event, it was added at the last minute. And as a result, the Supreme Court later said, well, we don't have a whole lot of legislative history to guide us in how to interpret this. So it was pretty interesting how that was kind of a last minute decision that turned out to be really important. So Title VII, basically, this is the statement of the law. It's unlawful to fail or refuse to hire, or refuse to hire or to discharge or otherwise discriminate against any individual with respect to the compensation, terms or conditions or privileges of employment because of that person's race, color, religion, sex, or national origin. So it's very broad. So how typically does discrimination occur? Usually it occurs when an employee takes what they call an adverse action against an employee because of an employee's protected status. And this can include suspensions, demotions, terminations, failures to promote, or even negative performance evaluations can in some situations be considered an adverse action if it appears that the disparate or that the treatment is different for this employee based on their protected status. And also adverse actions can also include sexual harassment and hostile work environments, and we're going to talk more about that. Harassment is basically any unwelcome act against an employee which creates a hostile work environment or unreasonably interferes with that employee's ability to do their job or any of the rights and privileges they have as a result of that job. Harassment, there's quite a bit of always confusion with this issue because people think any kind of harassment is actionable, but it's not under Title VII. It's only actionable if it is based on the protected status. So it becomes unlawful, harassment does, when you make it a condition of continued employment. Now, this is kind of a little bit, I think, referencing quid pro quo actions, and we'll talk about those in a minute. But essentially when somebody says, if you don't give me a sexual favor, for example, then I'm not going to promote you. So kind of this condition of continued employment issue where requires you to do something you don't want to do. And then the conduct is so severe or pervasive that it creates an environment that the person can't even really do their job. So it's a pretty tough standard to meet. Usually has a subjective and an objective standard. So you're not just looking at it through the eyes of the person who is making the complaint, but you're looking at it as a reasonable person would consider action and whether they would consider it to be intimidating, hostile, or abusive. So here's the quid pro quo that I was talking about, which is basically this for that, or tit for tat, or you hear that too. So this is usually a situation where you have a supervisor-subordinate relationship, and terms or conditions of employment, such as promotion, pay raises, etc., are conditioned on the subordinate's willingness to receive or reciprocate unwelcome sexual favor or advances. That's sexual harassment. Hostile work environment is basically what we were just talking about, where you can have a sort of a culture of unwelcome, inappropriate comments and behaviors that are sexual in nature, that are demeaning to one gender, that again interfere with that employee's ability to really perform her job. Hostile work environments do require this severe and pervasive conduct. So it's not usually considered a hostile work environment if you just have a stray remark that's maybe inappropriate, or you tell a dirty joke, you know, once or twice, probably not enough. It sort of has to be a pervasive problem to meet that standard. So factors that create a hostile work environment include how frequent and severe it is, whether it's physically threatening or emotionally humiliating, and then again, whether it interferes with the employee's job performance. And we talked a little bit about the subjective and subjective component already. One thing that the courts will say is Title VII is not a general civility code. And by that, they mean they don't want to hear every time somebody said something wrong or is just improper, you know, that they're there to really look at situations where people are being discriminated against on the basis of their status. And then there's a note here, I just want to point out that the ACE principles are actually more stringent than Title VII. So under county rules, you probably will get into trouble if you tell dirty jokes or make a stray remark. That can still get you in trouble, even if it wouldn't end up in a liability for the county under Title VII. So who can commit sexual harassment? Well, it can be committed by either gender, against the opposite gender, or the same gender. This Oncali case that's referenced here is a case in which it was same-sex harassment. And also they distinguish between this sort of simple teasing and what really constitutes a severely hostile or abusive environment and conduct. And a hostile work environment can be created by a peer or a subordinate, not just your supervisor. So there is automatic liability for harassment by a supervisor over a subordinate, unless the employer can prove two things: that they reasonably tried to prevent and promptly correct the problem, and that but the employee failed to take advantage of preventative or corrective measures provided by the employer. So this is where it becomes very important for the employer to have a process for filing a complaint of sexual harassment or hostile work environment. And if the employee fails to take advantage of that, then the county may have, or the employer may have, a very strong, what they call affirmative defense, which would allow them to potentially eradicate the claim. So if they did everything they could once they found out about it to correct the problem, and if they have a process in place where people can come, employees can come and make a complaint, and there will be an investigation if they do, probably, then and they don't take advantage of that, then the employer is more likely to prevail in the case. Even non-supervisory employees can create liability, not just supervisors, for an employer. So the Me Too movement, of course, has brought this sort of sexual harassment problem in the workplace out in the open, and more women have been encouraged to come forward with their stories of what's happened to them in the workplace. Here's some statistics. I think these maybe are a couple years old, but probably still pretty accurate. You know, like more than half of American women have experienced these unwanted and inappropriate sexual advances at some point in their lives. That's not surprising. 30% of American women endured such behavior from male colleagues in the workplace. That's kind of a high number. And 25% of those 30% said it was someone who had influence over their career. So this has been a pervasive problem. I think it's getting a lot better, but it's definitely still out there and still exists. So what's the best way to deal with harassment? If you're a manager or supervisor, you should actually not ignore it at all. If you get some sort of allegation, you need to immediately contact HR. And they'll probably open an internal investigation if it's warranted. Keep in mind, again, that harassment is not limited to just sexual harassment, but it still has to be based on discrimination as a result of that person's status. And this is Section 13 of the county's Personnel Policy Rules and Procedures Manual. Give you some more information on the processes that are required. All right, okay. So courts analyze discrimination cases by applying certain rules and different ways of analyzing the case. So I'm going to talk to you about these 5 different ways that the court will look at the case and make decisions. One of them is the establishment of a prima facie case, which is basically has the complainant actually alleged what he or she needs to allege. The burden shifting analysis, I'll talk to you about that. And the other 3, I'm just sort of listing them here to tell you I'm going to talk about these 5 things, but I'll move forward with them. So how do you establish a prima facie case? Well, a prima facie case is one that's accepted as correct unless proved otherwise. So there are these rules that what you have to allege if you're trying to allege a complaint. And you have to first state that you're a member of the protected class, that you applied for and that you were qualified for the job, or whatever your issue is, that you were terminated, whatever the adverse action is like the number 2 thing that you have to include. And you have to say, like if you're applying for a job, that despite the qualifications, you were rejected for the job. And then 4, usually they're looking at, okay, after you rejected, the position remain open, and more applicants sought or given the job who had the same qualifications as you have. So basically, all of these are going to be geared to, they're going to be customized for the situation, but they're all going to be geared to finding out whether or not the person was treated differently. So the McDonnell-Douglas case from 1973 establishes this burden shifting analysis. And this is, you see this in almost every single discrimination case that goes to a court. So under this analysis, the plaintiff has the initial burden of stating the prima facie case, as we talked about just a minute ago, and that employer has to articulate this legitimate, non-discriminatory reason for action. Once the employer does that, then the burden shifts back to the plaintiff to prove that the employer's proffered reason is a sham, that it's a pretext, that it's not true, that the real reason that they were discharged or not promoted or whatever is because of discrimination based on their class. So it's a interesting test. It's pretty easy to apply, but this is why we will typically always ask when someone is being disciplined for something or is being discharged or not hired, that it's very good for the employer to be ready with what their legitimate non-discriminatory reason for the action is. That it's much better to tell the employee, even if it's hard to tell them, we're letting you go because you have done X or you haven't done X, than it is to say, I'm not going to give you a reason. If you say, I don't have a reason, I'm not going to give you a reason, then it sort of leaves it open to the person's imagination, and they may begin to feel that it was a discriminatory reason. It was because of my race or because of my gender, etc. So you really need to think about this before you take action, which is, what is my reason? Make sure you have a reason. Make sure it's not discriminatory. The but-for rule comes into play a lot, and basically under this rule, it's really just a way of looking at the case and saying, if it wasn't for the person's protected status, this wouldn't have happened. And if you do that, then and the employer comes back and says, yes, but there were other reasons that we took this action, that it may not matter. So, you know, if only one of your reasons is discriminatory and you have 5 other reasons, you're probably still going to be liable. So this is sort of another just saying that you see in court, and you see in court cases a lot, which is, okay, you can make a wrong decision, but you can't make a discriminatory decision. So the court says, you know, while we ensure that employers do not act in a discriminatory fashion, we're not sitting as a super personnel department that re-examines every decision that a business entity makes. You know, the courts aren't set up for that. They don't have the manpower to do that. They don't want to run your business. So if you make a decision that's just a bad decision, maybe you thought somebody had done something and maybe they really didn't, or maybe you just, you know, thought this person, whatever reason you have, it's okay, really, as long as it's not discriminatory in terms of Title VII. So that, you know, you don't have to worry too much about it. There are other causes of action people might find out there, but under Title VII, at least, you can make a bad decision or a wrong decision and it not be something that somebody can sue you for under Title VII. The courts are also going to look at direct versus circumstantial evidence. So direct evidence, and I'm going to use a criminal example because that's a little easier to understand. Say there's a witness sees a person shoot somebody with a gun, right? Okay, so that's pretty direct evidence, right? Or they happen to be there and they see the smoking gun and the person laying on the ground. That's probably direct evidence that that person committed the crime. But if you just see somebody running away from the scene, maybe they even have a weapon, maybe they don't, but that's going to be circumstantial evidence. So there isn't that much direct evidence anymore in Title VII cases because thankfully employers have wised up to the idea that they shouldn't say stupid things. So, you know, you don't have too many employers saying, I'm not going to hire you because you're a woman. They know better now. They aren't going to do that. So most of the evidence in discrimination cases really is circumstantial. And that would be things like the timing being really suspicious. So you announce that you're changing your gender and then you get fired, which we're going to talk about that later. Or you make, or the person who's your boss makes these ambiguous statements like, oh yeah, you know, old people have a hard time with this job or something like that. You know, so this is usually how it happens. Maybe, you know, maybe even they just ask them, so aren't you retiring this year or something like that? But these kind of statements, they're usually circumstantial evidence, but they are used in court. And sometimes now too, we're seeing statistical evidence being used more. Those are typically in class action cases, which I'll talk with you about a little bit in a few minutes too. So this is kind of how sex discrimination has evolved in terms of causes of action that come before the courts. Here in the beginning, it was a lot of quid pro quo. You had a lot of cases in which women were sexually harassed in the workplace, or told they couldn't have a job or keep their job if they didn't provide some sexual favor or something. Those were early cases. There were a lot of those. But then it evolved, and I think even there was some thinking in the beginning, this is what we were going to be looking for only. But you could see over time that it's really broadened. And so Pregnancy Discrimination Act, which came out in 1978, focused specifically on discrimination against women who were pregnant or had medical issues related to their pregnancy. Sexual stereotyping came out as a sort of a reason to find discrimination in 1989 with the Price Waterhouse case. Same with sexual harassment, hostile work environment, pay disparities, statistical differences in gay and transgender rights. So all of these things came out over time as causes of action, and it became a more inclusive umbrella for anything related to sex discrimination. And I'm going to go through some of these cases with you because they're really interesting. I think you'll like them, hearing about them. Okay, so Price Waterhouse is a case from 1989, goes to the Supreme Court. And in this case, the plaintiff had sued her employer, which was the Price Waterhouse accounting firm, for sex discrimination because they denied her a partnership because they didn't think she was acting feminine enough. So the employer said, well, we would have denied her this partnership anyway. And the court held that their actions constituted sex discrimination under Title VII because they had engaged in gender stereotyping. They had, this really was a kind of mixed motive case where they had other reasons besides that for not making her partner, but the fact that they had considered her, whether she was sexy and feminine enough, was enough to be to meet the qualifications for sex discrimination. This is also a pretty early case. Now, the Jacksonville Shipyards case, which did come out of Jacksonville, Florida, is a really seminal case, but it's really, when you read it, you really can't believe how bad it was. So the plaintiff, Lois Robinson, was a welder, and she sued the Jacksonville Shipyards for sexual harassment. She asserted that the company had created and encouraged this sexually hostile environment. And indeed, they had photos of nude and partially nude women from Playboy and Penthouse magazines, nude calendars. All of this just pervaded the workplace, including the offices of managers. The plaintiff herself endured a lot of demeaning remarks by male employees and supervisors. They would like pull out these magazines and start talking about them while she was in the room and make these sexual comments and jokes that they directed at her. And they even like painted these really crude names, sexualized names for her on the wall where she worked. So there were only about just a handful of women that worked for the shipyards. There were like 1,000 men that were there working as craft workers, skilled craft workers. And so it was considered a man's world, and the employer had done nothing to end the mistreatment. So that company was held liable for the hostile work environment, rightly so. This case from 1998, Burlington Industries, involved a saleswoman, and she was subjected to constant sexual harassment by her supervisor. And the supervisor makes these threats. He says he's going to retaliate against her if she doesn't give him what he wants. And the question was, well, okay, did she have a claim? And the court said, well, yes, she had a hostile work environment claim, but she didn't have a classic sexual harassment claim because he never made good on the threats. I don't know if the courts would find that way today, but that's what they found in this case. And they said that, in fact, she would have to prove that it was a severe or pervasive hostile workplace, that the conduct was very severe and pervasive all the time in order to prevail on that claim. So this again talks about when an employer is liable for damages, and I touched on this a little bit earlier, but thought it wouldn't be bad to reemphasize it. So the best thing to do if you know about sexual harassment is to try to stop it. You might have to reassign some people, and if you do that, it's usually best to reassign the perpetrator and not the victim. And also, if you take adverse action against the employee who's making the complaint, that can be a problem as well. So the affirmative defenses I was speaking about earlier are this reasonable care to prevent and correct and promptly any sexual harassing behavior, and if the employee unreasonably fails to take advantage of these corrective and preventative opportunities. So you might know about this case. This was a pretty famous case, 2007. So Lily Ledbetter had worked for Goodyear for like 19 years, and she receives this note saying that she's making thousands of dollars less than her male colleagues who are doing the same job. And so she files a discrimination complaint against Goodyear for paying her significantly less than her male counterparts. And the Supreme Court says, sorry, but you missed the deadline. So to file a discrimination complaint, you have to file it within 180 days of your knowledge of, or the incident itself, or your knowledge of the incident. And of course, she didn't know about all of this stuff that had been going on for years until, recently for her. And so, so that's what happened. But as a result of that decision, the President Obama, who's new into office, signs the Lilly Ledbetter Fair Pay Act of 2009. That's the first bill he signs after he becomes president. And it directly addresses this conundrum and resets the 180-day period to start anew each time you get a paycheck. Walmart v. Dukes is not going to go into a lot of detail with this case, but it was interesting because it was an attempt to file a class action lawsuit against Walmart that would be joined by like 1,500 women who work for Walmart, who said that they didn't get the same promotional opportunities or the same pay as men. And so this actually, let's see. Okay, so this was estimated to comprise more than 1.5 million women in this class, including all women that had been employed by any Walmart nationwide at any time after December 26, 1998. So it would be the largest class action lawsuit in US history. The court said they could not sue, not have a class action with this many people in it. And basically said that all of these women who believe they've been discriminated against would have to file individual lawsuits. And the reason for that is because there's a commonality requirement with class action lawsuits. So if you have, you may have received in the mail before, like, would you like to join this class action lawsuit? And it would maybe be against the phone company and you would be owed $1, say. And so in a case like that, if there's 1 million people that are in on it, it becomes worthwhile for the people who file the complaint. But it doesn't, it's not too hard to continue with that kind of case because they all have the same set of facts, right? But in this case, all of the employees would have different facts as to why they didn't get promoted or paid a certain price according to the courts. So that's why they didn't hear the case. So Title VII is supplemented with other legislation. The Pregnancy Discrimination Act, of course, which we'll talk about a little bit more in detail in just a minute. USERRA, which is the Uniformed Services Employment and Reemployment Rights Act. And this essentially protects soldiers who leave their job to go be in the reserves or, and they want to come back, right? So you have to hold their job open for them. And also employers cannot discriminate against persons who are in the military. ADA, so that comes up every once in a while. We have cases on that from time to time. The ADA, of course, the Americans with Disabilities Act, which was passed in 1990 and was modified substantially in 2008. And then the Age Discrimination and Employment Act of 1967. So this was an early add-on, which prohibits discrimination against persons 40 or older, which seems kind of like a low number now. To me, I don't know if anybody else thinks that way, but most people are working longer than they did in the 60s. And then GINA, the Genetic Information Non-Discrimination Act. So yeah, here's a little bit about USERRA. It prohibits discrimination based on military status. It does set a 5-year limit of time that an employee can be absent from work for military duty and still retain your reemployment rights. And it does provide protection for disabled veterans, so you have to provide accommodations to them, just like you would of any disability, really. And it allows them to return with the same seniority and status and pay. And they have to be provided with their health insurance for up to 24 months. The Genetic Information Non-Discrimination Act, GINA, basically protects genetic information regarding an individual or family member. And these are kind of the 4 basic categories, that are protected: genetic tests, genetic services, family medical history, information about a fetus, or information on an embryo obtained for assisted reproduction purposes. So this is the last set of statistics that we got from the EEOC showing how many claims were filed in fiscal year 2019. And you can see that retaliation is the greatest number by far. And the reason for that is because the reason that you have more retaliation claims than any other type of claim is because people tack on retaliation to their other claims. So they might have a claim for disability discrimination, and in the process of that discrimination, they may feel that they were also retaliated against for filing that claim. So people often file those, attach them to others. But you can see disability is the second largest, and then race and sex are very close at the 32-33% range. Few age discrimination, not too many, and then the numbers go down significantly for the other categories. Here's the kind of some of the overall statistics: 72,000 plus charges filed with the EOC in 2019, 6,000 almost in Florida. This, by the way, is the lowest number in 10 years. The highest in the last 10 years was an 8,000 number in 2011. Yeah, so I think that's good news for everybody, that these number of cases seem to be going down, which I think indicates there's less discrimination that's happening. There was a small rise in the caseload, went up by like 500 cases in 2016, but otherwise it's been kind of on a downward projection. Okay, I think this is a good time to take a break and maybe 10 minutes, and we'll come back and finish up. Hey, Kyle.
Yeah.
All right. I'm going to talk with you now about the Americans with Disabilities Act. And then after I do that, I'll talk to you about 3 or 4 other areas of discrimination law. So try to get it done and get you out of here in an hour or less. I did, though, before I start on the ADA, I wanted to ask if anybody had any questions about the last segment, about Title VII, about race discrimination or sex discrimination in particular, or any other type, really. Okay, then we'll move on, and you'll have another opportunity if you think of something that you'd like to. Let me look, though. I guess I should look and see if anybody has sent me anything. Okay, I don't see anything. So, okay.
Hey, Sarah, real quick before you continue, I did have one question pop up. Are your slides going to be available for reference after today?
Sure. How would you like me to handle that? Should I just send it to the participants?
Yeah. If you want to reply all to that invitation that I sent everybody, you can attach it there.
Okay, sure. Love to share it. Okay, so the ADA, before I get into sort of the nuts and bolts of the ADA, I just want to talk a little bit about the disabilities rights movement. Of course, people with disabilities were not included in Title VII, and they faced really significant discrimination. They often were not hired for jobs they were qualified for. They couldn't often even get into the building to apply for the job or interview for the job. There were no requirements that that people remove architectural barriers or physical barriers. There weren't ramps. There weren't, they couldn't get into restrooms. It just was really hard for them. Not to mention like programmatic barriers, like participating in programs, government programs or private sector programs. So they began to mobilize, especially in the 70s and 80s. And there was an early law, which you've probably heard of, it's still in the books and still used, called the Rehabilitation Act of 1973. And that law did, for the first time, prohibit discrimination on the basis of disability, but it was a kind of limited law. It applied mostly to governments, local governments that got federal money. And so the schools had to start following that. And in fact, they still do. You might, if you've had any experience with a child with a disability, you've probably heard about Section 504, which is the section that requires schools to not discriminate against children because of disabilities. So yeah, up until this time, children with disabilities weren't even necessarily allowed to go to school. Or if they did go to school, they were placed usually in a separate classroom with other people with disabilities. So they began to mobilize in the 70s and 80s, and they were really successful with their tactics. They did sit-ins at the Congress that went on for weeks. I mean, just waited around until people would agree, with them that they needed to have these laws signed. And then they would stop traffic with their wheelchairs, like on a busy street in New York City. And one of the most famous things that they did was a crawl up the steps of the Supreme Court building, I believe it was. And this was people, old, young, children and old people and all kinds of people with all kinds of disabilities who were crawling up these 100 steps or however many there were. And so that made a really big visual impact. And eventually the ADA was signed. It was signed in 1990 by President George W. Bush. It was a bipartisan effort. It was a very welcome law for many people. So we're going to talk about today who's considered disabled, who's qualified for a job, a little bit about accommodations and what employers must do to accommodate persons with disabilities, and a little bit about what a supervisor should do if they're told that somebody has a physical or mental health condition. So who is disabled? To be considered disabled, the person must be able to perform the essential functions of the job. You'll hear that phrase a lot if you start working in this area of the law. It becomes just something that rolls off your tongue, the essential functions of the job. So in order to establish a prima facie case of discrimination under the ADA, the plaintiff has to demonstrate that they're disabled, that they're a qualified individual, and they were subjected to unlawful discrimination because of their disability. A physical or mental impairment is described in the law, and an individual is considered to have a disability under the ADA when they have a physical or mental impairment that substantially limits one or more major life activities. So a physical or mental impairment means basically any physiological disorder affecting one or more body systems. So what does it mean to be substantially limited as to major life activities? It means you're unable to perform them, these major life activities, one or more, or you're significantly restricted as a result of your condition compared to the average person. So if you're substantially limited in your ability to work, it means that there's a broad class of jobs you can't perform. So it's not just that you can't perform this one job. So people don't always remember that when they're, if they file an action, if they didn't get a single job, or they can't do a single job, that doesn't mean they can't get other jobs. So that they won't be considered substantially limited unless it's a broad range of jobs they can't perform. And that's pretty much that issue. Okay, so here's the list of major life activities. And this is the original list before 2008, and then the additional activities that were added after 2008. But this is not like a definitive, exhaustive list, as I understand the law. There could be other major life activities that could also apply besides these. But you could see these are pretty much the basic things that we all pretty much do every day if we're not disabled. And so it's interesting to think about what are the things that people actually can't do that are very basic like this, these major life activities. And that's what makes them disabled. So they expanded this list in 2008 to include these major bodily functions. So if you have problems with any of these areas of the body, you probably are going to be disabled because these are kind of major things. So if your brain is not working correctly, you have neurological problems, respiratory, circulatory, endocrine, you can see these are the major body's functions. And if you have any of these that aren't working properly for you, you probably would be considered disabled. I do want to say one thing about why they changed the law to broaden it, to make it clear that more people are disabled. And that's because what was happening with the ADA is many people were being found to not be disabled. So a lot of claims were being rejected and cases were being lost by plaintiffs because the courts said, oh, you're not really disabled. And one case I remembered was, I think it was out of North Carolina, and a young man had applied for a job at Walmart, and he had cognitive disabilities. He was probably labeled then mentally retarded. He may have also been Down syndrome. So he applies for the job and he asks if he can bring his job coach to the interview. And Walmart says, no, you can't. And so he sues, and the court comes back and says, well, you're not disabled enough, or you're not disabled. So this was a person that with MR, this person was disabled. So the courts were just, really able to use a whole lot of discretion in that area. And a lot of people were feeling that the system wasn't working. And so in 2008, they added a lot of, they broadened it a lot. And so now people kind of say, oh yeah, anybody's disabled under the ADA, but it's not really true. But it definitely did get expanded. So you can violate the ADA by treating somebody differently because you perceive them to have a physical or mental impairment. And just something to be aware of, sometimes there are a lot of people that are disabled that aren't diagnosed. And that's, of course, their personal decision to make. But occasionally in the workplace, you will meet someone who you think is impaired, even though they don't identify themselves that way. And you can, if you treat them differently, you could be found to violate the ADA, even if they're not really impaired. So just a good thing to know. So some conditions will almost always result in a determination of disability. And so if you have these situations, you probably don't even need to seek much information from a doctor if it's apparent. So some of these conditions are very apparent. Of course, blindness, deafness, intellectual disability is usually apparent too. If you're in a wheelchair, autism, cancer, cerebral palsy, diabetes, epilepsy, these are things that might be predictable and apparent. So you might still need, you might still need to get a doctor's note. I'm not saying you shouldn't get one. It's always good to have that. But some of these things you can just predict that they are disabilities, and you don't have to do a whole lot of analysis. So the gist of the ADA is that disabled persons have to be given accommodations so that they can work in the workplace. And so if you're a qualified individual with a disability, you can seek an accommodation, and the employer really has to grant it unless it would cause an undue hardship. And an undue hardship is a very tough standard to meet. It has to essentially be something that is really difficult or expensive, difficult to do or expensive. You sometimes see too the term that it would substantially alter the fundamental nature of a program. So, you know, you don't have to totally change the way you're doing business, but if it's really significantly difficult and it would do that, then you can usually say no to the accommodation. But the expense part, you almost have to be really impoverished as a business to be able to get that. So an accommodation is generally any change in the work environment or in the way things are customarily done. So that would enable this person with a disability to enjoy these equal employment opportunities. Here's a list of some of the things that are possible to modify or adjust. Certainly the job application process. I know now for the county that's primarily online, but which probably helps make it accessible to more people. The work environment itself can be modified or adjusted in lots of ways. Even the way a position is customarily performed. So these just are things to think about if you have a person with disabilities and they want to apply for the job, or they are already in the job and they can do the work. But what are the things that you can do to modify or adjust the environment to make it possible for them to do that? So physical barriers, of course, have to be removed under Title II, or Title III, I'm sorry, Title III, Title III of the ADA. This is not, employers do have to deal with this. And in fact, the counties have been kind of on the hook all over the country lately because they have not been doing enough to remove physical obstacles and other obstacles like programmatic obstacles. So one of the things you can do to remove barriers in the workplace is to look at your procedures and rules and see if those as written could be modified if somebody needs them modified in order that they can perform their job. And you can consider changes to hours and schedules and equipment and assignments and policies. So employers do not have to eliminate the essential function of the job. You don't have to let them off the hook for having to do the fundamental duties of the position. That's still going to be required. You don't have to even allow up for a lower production standard, or and you don't have to provide them items that they might need if they're going to use them on and off the job. So especially things like personal items like glasses or canes or different things like that that they'll be using themselves all the time. But you might have to provide them with some technological equipment or other things that would help them to function in their job. So what do you do if your employee requests an accommodation? This may be the first step in what's called the interactive process, which is usually an informal meeting between the individual and the employer. And before you address the merits of the accommodation, the employer will usually need to determine if they are disabled, and will usually ask for a medical diagnosis, or maybe not a diagnosis, but just a medical statement from a doctor. So here's some things that the employer can ask an employee. If they perceive that they're having problems with their work that might be as a result of a disability, you can certainly ask what problems are they experiencing, what type of reasonable accommodation do they think is needed. You can ask the nature of their disability and their functional limitations. And you can ask them to provide this documentation from an appropriate health professional that establishes their disability or limitations. So when it comes to leave requirements, if a person needs leave as a result of their disability, they're entitled to leave without pay if there's no available leave for them. And you can let them take leave without pay if there's no other way to deal with the problem. So in that situation, the employee would usually use their accrued leave first and then their unpaid leave. Typically, the employer would hold open their position until, unless it's an undue hardship, and they should be able to return to the same position if they're still qualified and can perform the essential functions with or without reasonable accommodations. So this is the basic FMLA requirements, which are a maximum of 12 weeks of leave for every 12 months worked. There's a guaranteed return to the same position or equal one. You can use your accrued time first. I think you might even be required to use your accrued time first in the county. And then you go to unpaid leave. You have to continue their health coverage, and you can't retaliate against them. And you can't discuss their medical information with others. So that's kind of just the basics of FMLA leave, which is of course unpaid leave. Pregnancy discrimination. The reason I'm going to talk about this is because it's something that's fairly new. It's actually a few years old, but it's still something that a lot of people maybe aren't aware of. It's very short. It's about 5 minutes. And I should tell you too that after this little segment, there'll be a segment on retaliation, and then a segment on LGBTQI rights. So that's, and then we'll be at the end. So we're moving pretty quickly here. Okay, pregnancy discrimination has been in Title 7. It was an amendment to Title 7. It was seen as something really important after Title 7 was enacted, because the number of women in the workforce almost doubled, and pregnant workers and women with children were more than twice as likely to be employed as before Title 7 passed. And in fact, women comprise nearly half the workforce now. So the Pregnancy Discrimination Act and the Americans with Disabilities Act and the Family and Medical Leave Act all kind of go together to help ban discrimination in the workplace against people who are women who are pregnant. So pregnancy discrimination and disability claims filed with the EEOC increased by 52% during the last decade. So we saw that it's the #1 claim that's made with the EEOC now. The Pregnancy Discrimination Act amended Title VII to expressly prohibit sex-based discrimination because of or on the basis of pregnancy, childbirth, or related medical conditions. So the way the law is now, you can't discriminate based on pay, job assignments, promotion, layoffs, training, or fringe benefits. And you can't fire, refuse to hire, demote, or deny promotion to a pregnant woman because of her pregnancy, if she can perform the job. So this was actually probably one of those areas of discrimination that people didn't pay much attention to for a while, but they're having to pay more attention to now. I think it was a very common question to ask women who were applying for jobs whether they intended to have children. That was a question I remember getting. And I think that too, there was sort of a way in which people were kind of paternalistic about pregnant women that sometimes was not what the women themselves wanted. For example, I had a client once who owned a restaurant, and they were trying to take away the waitress's ability to carry anything heavy because they thought they wanted to protect her. And she filed a discrimination complaint against them. So basically, you have to treat pregnant women as you would anybody else for purposes of the discrimination laws. You don't want to deny them the ability to do their job because they're pregnant. Now, let's see, so you have to treat women affected by pregnancy the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. So this is a prelude to a discussion about a case. Let's see if it shows up. Yes, okay. Young v. UPS. Okay, so the issue in this case was whether a pregnant employee could go on light duty. So UPS in this situation had a policy where people who were injured on the job could go on light duty, but they didn't apply that to women with pregnancy. So the question in the case was, must an employer that provides work accommodations to non-pregnant employees with work limitations provide those same accommodations to pregnant employees who are similar in their ability or inability to work? So in this case, Peggy Young, who was a UPS driver, requested light duty. Her doctor told her she couldn't lift more than 20 pounds, and drivers usually lift up to 70 pounds. So UPS refuses to offer her light duty work, even though they offer it to workers who were injured on the job and workers who had recognized impairments under the ADA, or even workers who had lost their commercial driving licenses. So she's forced to take unpaid leave, and she eventually loses her medical coverage. So the plaintiff argued that the Pregnancy Discrimination Act requires an employer to provide the same accommodations to workplace disabilities caused by pregnancy. And the same type of accommodation that they would provide to someone else who had a workplace disability. And the defendant said, yeah, but the Pregnancy Discrimination Act added pregnancy to Title VII, but it doesn't require us to provide accommodations to a pregnant woman. So the U.S. Supreme Court, this is what the United States argued, because the United States got involved and the EEOC got involved in this. And they said an employer may not refuse to treat a pregnant worker the same as other employees who are similar in their ability or inability to work by relying on a policy that makes distinctions based on the source of an employee's limitations. And for example, a policy of providing light duty only to workers injured on the job. And the court agreed with that and said that she belongs to the protected class and she sought an accommodation. The employer did not accommodate her, but did accommodate others who were similar in their ability or inability to work. So the Supreme Court said, in their 63 decision, they accommodated all these others. So why could it not accommodate pregnant women as well? So that was a good case for pregnant women and their families. An employer, this is the EEOC guidance now, obligated to treat a pregnant employee who's temporarily unable to perform the functions of her job the same as it treats other employees who are similarly unable to perform their jobs, whether by providing modified tasks, alternative assignments, leave, or fringe benefits. Okay, now retaliation is, of course, the number one claim, as we discussed earlier. And I'm just going to explain that to you. This is a short presentation, but you'll get the gist of what this means. Okay. Okay, some of the laws that prohibit, I don't know why that's happening. Some of the laws that prohibit discrimination also include retaliation provisions. And you can see the list up there. It's pretty much all of the discrimination laws that are covered by Title VII or that have been, or supplement Title VII. And then the Florida Civil Rights Act, which also, it kind of mirrors a lot of Title VII, but it's a specific state cause of action that you can bring for discrimination. All of those prohibit retaliation. And also other laws prohibit retaliation, such as whistleblower protections, workers' compensation, and other jobs where someone can request a reasonable accommodation or job protected leave. So a person can bring a claim saying, as a result of their filing, for example, a workers' compensation claim, they were retaliated against. So let's see, the most frequently alleged basis of discrimination in the federal sector, right, is retaliation, which we just said. And it's unlawful to take adverse employment action. Remember, that's things like suspension and termination against an employee who has engaged in protected activity. And that includes acting as a witness in an equal employment opportunity charge or investigation, refusing to engage in an act that would be unlawful discrimination, or exercising one's rights under another law. So people are protected if they need to come forward and testify as to something they saw in the workplace that was discriminatory, or if they're told to do something that's discriminatory and they refuse to do it, you're going to be protected, and that's where you can have a retaliation charge. So here's some of the activities that are protected from retaliation. Filing or being a witness, as we just mentioned, communicating with a supervisor or manager about discrimination occurring, answering questions during an employer investigation of alleged harassment, refusing to follow orders that would result in discrimination, resisting sexual advances or intervening to protect others, and requesting an accommodation of a disability or for a religious practice. So here's the elements of a retaliation claim. You have to allege that you participated in a protected activity, and there has to be some then adverse action that was taken against you as a result of you participating in that protected activity. And there has to then also be a connection. So say you participated in a investigation about sexual harassment a year or two ago, and then 2 years go by, and then you're given a bad review on your performance evaluation. Well, that might not be causally connected. It seems, 2 years have gone by. Why would the employer just now be taking this adverse action against you for your participation in protected activity? So there is sort of a requirement there that there be a connection between the protected activity and the adverse action. And here's just some types of adverse actions that we've talked about already, but you can see things like even disparaging comments or making false reports. These are sort of things that might happen that are not work-related, where you can also end up with a retaliation claim if you are taking actions outside of work that are seen to be a threat, a result of their having participated in a protected activity. Okay. I must have hit something. I don't know why this is suddenly doing this. Okay, so the causal connection element, again, that's when there's a causal connection between a material adverse action and the individual's protected activity. So the but-for causation standard, see if I can get anything else to come up here, is for retaliation claims. Okay, so the but-for causation standard also applies in retaliation claims, sort of where you're saying, but for, excuse me, their engagement or participation in this activity, I wouldn't have been disciplined. So that's the but-for test being used in that situation. And these are some of the factors that would support finding of causal connection. This is the suspicious timing, if it's very close in time, and you're looking at documents and trying to see if there are statements that you can look at to show that there was a connection between these events. Okay, so this is the last segment, and I think it's one of the most interesting that we have. It's the evolution of lesbian, gay, bisexual, transgender, genderqueer, and intersex rights. So this is a very evolving area of the law, although lesbian and gay and bisexual people have been struggling for decades to have these basic civil rights. And what has remained uncertain has been rights in the workplace. So that has been actually resolved by a Supreme Court decision that happened this summer. And so I'll tell you about that. So some of the questions that have persisted, even as more employers have been very open to having gay and lesbian employees, there has been sort of a question about transgender individuals and other individuals who identify maybe as no gender or some middle gender, and who otherwise don't conform to gender stereotypes by their appearance or behavior. So those are the questions that kind of we were looking for good answers to. Here's an interesting slide. I got this from my husband. He's a professor, and one of his colleagues had put this together that kind of shows this umbrella of different identities that people might claim that kind of all fall under this transgender umbrella. So you can see that there's lots of different ways that people might describe themselves. And I think that one of the messages that they're trying to say here is that you don't really have to know the label, but anybody who is discriminated against because of their gender or lack of gender or different gender, that's going to be a violation of the law. There's a really nice note on the very bottom right, which says, you don't have to remember these words, but just have a respectful attitude and an open heart. And I thought that was kind of good. So let me tell you where we are now. So laws prohibiting discrimination based on sex or gender protect individuals who do not conform to gender stereotypes, who self-identify as a gender other than the one that was assigned to them at birth, and who are transitioning or have transitioned to another gender. So I'm going to take you back a little bit to some of the earlier laws, and you can see the progression. This is Macy versus Department of Justice case. It was from 2011, and Mia Macy had applied for a job with Alcohol, Tobacco, and Firearms, the federal agency, as a male, and they told him the position was his. And then a couple months later, he informs the federal agency that he's transitioning from male to female, and they give the job to someone else. So originally, Mia Macy files a complaint with the EEOC, and they don't accept the claim because they say transgender status, even at that time, sexual orientation status, is not covered by Title VII. So then we had the EEOC completely change its position on this and say, no, we think this is right. We think discrimination based on gender identity or change of sex or transgender status is discrimination based on Title VII. So this was the real turning point in employment discrimination law on this subject. So under the Mia Macy decision, the term sex encompasses both sex and gender. So it encompasses both biological differences and kind of gender stereotyping. And the terms sex and gender are used interchangeably to describe discrimination prohibited by Title VII, and employers can't take gender into account in making these employment decisions. Now, Price Waterhouse was another case, 1989, the U.S. Supreme Court heard, and this was an interesting case where I think I talked about it already, so you may already know about this case. Okay, this is the accounting firm that failed to promote Hopkins to partner because she wasn't feminine enough. And her partners told her she had to dress and talk and walk more femininely, and they told her to wear makeup and have her hair styled and wear jewelry. And in the end, they tried to say, oh, well, we didn't really not give her partner because she wasn't feminine enough. There were other issues, but the court said, well, you've already, there's already this established rationale, and you've said it's based on her failure to conform, her gender nonconformance. We think this is sex discrimination, even if you did have some other motivations. This is a 2011 case out of the 11th Circuit Court of Appeals, and this is the circuit that Florida, it includes Florida in its jurisdiction. In this case, the employer was found to have violated the U.S. Equal Protection Clause because it fired a transgender employee who was born a biological male because she appeared and behaved like a woman. So the employer admitted that he considered it inappropriate and unsettling and unnatural for her to come to work dressed as a woman. And the court basically said she's protected from discrimination. Actually, she's transgender, so biological. So right, so she became a woman. So she, you know, person is protected from discrimination for gender stereotyping, even if it makes the employer uncomfortable. So if they're uncomfortable with it, or they don't like that the person is identifying as transgender, it doesn't matter. It's still discrimination. Here's the new case, June 15th, 2020, out of the U.S. Supreme Court. And it's actually a consolidation of 3 different cases, but it's named Bostock v. Clayton County, that being just the first case, perhaps. I'm not sure why they chose that one. But it attempted to answer the question, can employees be fired simply because they are homosexual or transgender? And the court said no. Title VII makes it unlawful to discriminate against the individual because of that individual's sex, and that this would be a violation if you fire someone because they're homosexual or transgender. This case involved 3 longtime employees. Gerald Bostock had been a exemplary employee for Clayton County, and he then decided to participate in a gay softball league, and they fired him. They said his conduct was unbecoming, and so he was fired after quite some time. Donald Zarda was a skydiving instructor in New York, and he'd worked several seasons with the company, and he mentions that he's gay, and then days later he is fired. Amy Stevens had worked for a funeral home and for 2 years, and then she started getting psychiatric treatment for her despair and loneliness, and they said they thought she had dysphoria, and they recommended that she begin living as a woman. So in her 6th year with the company, she wrote a letter to the company saying, I'm going to live and work full-time as a woman when I return from vacation. And they said, well, you're fired. This isn't going to work out. And they fired her before she went on vacation. Okay, so the Supreme Court's analysis was this, that Title VII makes it unlawful for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against them because of their sex. And the straightforward application of Title VII's terms, interpreted in accordance with ordinary public meaning at the time of their enactment, resolves these cases. So an employer violates Title VII when it intentionally fires an individual employee based in part on sex. It makes no difference if other factors besides the plaintiff's sex contributed to the decision, or that the employer treated women as a group the same when compared to men as a group. So again, we're talking about the but-for test here. So the court said the plaintiff's sex was the but-for cause. It was only one of various causes, but it was enough to trigger the law. Okay, this is actually a very short video. I was going to show you about this subject. I think it's good to get some context. This is the last case I want to talk to you about. It's the Obergefell versus Hodges case, actually 5 years old already. But this is the case in which, lesbian and gay individuals were given the right to marry. And I'll tell you a little bit of what the court said in that case. They said that the right to marry, which is guaranteed to same-sex couples, is a result of the Due Process Clause, the Fifth Amendment, and the Equal Protection Clause, the 14th Amendment. The Due Process Clause imposes equal protection requirements on the federal government, and the Equal Protection Clause applies only to state and local governments. So they saw it as an equal protection constitutional issue. And they said that as a result, under the 14th Amendment, which has been in effect for over about 250 years now, 150 years, the states cannot deny any person equal protection of the law and must provide equal justice under the law. This requires that individuals in similar situations be treated equally by the law. So this was a 5-4 ruling. It requires all 50 states to perform and recognize the marriages of same-sex couples on the same terms and conditions as opposite-sex couples with all the same rights and responsibilities. So now I'm hoping maybe you might have some questions. That's the end of the presentation.
Can that same-sex law be overturned by new justices that are coming in?
Well, essentially what would have to happen is I guess a similar case would have to come before the court again, and or a case involving this question would have to come before the court again. And if it did, it is possible that the court would have a majority and might try to overturn this case. I think that there are already 2 justices that have suggested they would like to overturn this case, and that has some people concerned for sure. And I think, though, that we'll have to kind of wait. The way it works for courts just can't make policy decisions, just decide that from now on, you know, this is going to happen. I mean, they provide opinions, you know, that become the law of the land, but those opinions can be overturned by subsequent opinions. But this has set a really large precedent, and so it'll be interesting to see if this is going to now come around again, even though it's only been 5 years. Good question. Thank you.
Does anyone else have any questions for Sarah?
All right. Well, thank you all very much. I appreciate getting a chance to talk to you, and hope to meet you in person at some point.
And before everyone signs off, just for attendance purposes, if you can type in your names into the chat, just so I can note it down that you were here. Otherwise, if you don't have anything else for Sarah, it was great seeing everyone, and we'll see you at the same time next week on Wednesday at 1 p.m.
Great. Thank you.